Good afternoon, Facebook family. Thank you for tuning in today to our live broadcast. Today I'm going to be talking and discussing custody options as it pertains to third parties, specifically grandparents. I am currently live on Facebook and Instagram, so I will be looking in different directions at times. I'm attorney Jeffany Roy. I am the senior attorney here at the Fairell Firm located in Tucker, Georgia, right off of 285. Here at the Fairell Firm, we have a focus on family law litigation, which covers all things related to family. Those things include custody, child support, divorce, adoptions, wills, power of attorneys, etc. In addition to those, our other side of the practice is personal injury. So if you have been in a car accident, give us a call too. If you want to know more about the Fairell Firm team, please head over to our website at farrellfirm.com. Or you can reach us at atlantacustodylawyers.com. You can also stay tuned and stay connected with us by following us on Facebook, Instagram, and YouTube. By tuning in today, you acknowledge that the information given is for informational purposes only, and information given is based on the laws of Georgia. Every case is different, and you should seek personal legal advice if needed. By participating in this broadcast, you understand that we are not creating an attorney-client relationship. I take questions at the end of the broadcast, and you can feel free to ask any family law questions, even if it is not this topic. You can type your questions at any time, and I will get to them in the order received. Custody for grandparents. For many, being raised by a grandparent is a common normality in many cultures for a variety of different reasons. The grandparent head of households form for many reasons, with the most common being that the family needs help from the grandparent generation. Custodial grandparent households usually form after even more serious difficulties, such as when parents are unable to take care of their children because of incarceration, child maltreatment, or mental health or substance abuse. For some, the grandparent arrangement is temporary, but for others, it becomes an indefinite commitment, and for some, a permanent commitment. Grandparent means the parent of a minor child, the parent of a minor child's parent who has died, and the parent of a minor child's parent whose parental rights have been terminated. Parents of fathers who have not legitimated children born out of wedlock are not considered grandparent under Georgia law. For example, if your son has children that he was not married to the mother when he had these children, or he did not subsequently marry the mother, nor did he file a legitimation for these children, those children, although biologically his children, are not your grandchildren by Georgia law. So a question that we get asked quite often is, can parents have legal custody? In any action involving the custody of a child between the parent or either parent and a third party, such as a grandparent, parental power may be lost by the parent or any other person if the court determines that an award of custody to a grandparent is what's best for the child. They have to determine that it's in the child's best interest and it will best promote the child's welfare and happiness. However, there is a rebuttable presumption, meaning it's assumed that the natural parent is a better parent, that it's in the best interest of the child for custody to be awarded to the parents. But this presumption may be overcome by a showing that an award of custody to such a third party as a grandparent is in the best interest of the child. The sole issue for determination in any such case shall be what is in the best interest of the child or children. In addition to the best interest of the children, the grandparent would have to show by clear and convincing evidence that the child would suffer harm in the care of the biological parent And if that harm standard is met, they must then show that the grandparent custody will best promote the child's welfare and happiness. So there's a couple of prongs that have to be met before a grandparent can take custody of a minor child. So clear and convincing evidence is a step above what is usually the determining factor, which is a preponderance of the evidence. So that's a higher showing of the court. And then after you have clear and convincing evidence, you have to show that it will promote the child's welfare and happiness. Temporary guardianship is a wonderful tool for grandparents needing quick parental authority over their grandchild. A temporary guardianship grants the grandparent or any third party the rights to do anything a parent could do. The most common need for the guardianship is when children are school age and now need to be enrolled in school. There must be a guardianship in place to do this with most school districts. Another common reason is to have the ability to get health insurance under a grandparent's policy or through the state if the grandparent applies for assistance. How to get a temporary guardianship. To get a temporary guardianship, the parents must consent. It is not possible to get the guardianship without consent. Once consent is given, the grandparent files the petition for guardianship along with the consent. Depending on the county, it could be granted right away, but some counties will require a home visit of a guardian ad litem investigation, which is a third-party neutral that basically would go into the house and talk about or look at the house and make sure that it's suitable for the child or children. How long does a temporary guardianship last? Temporary guardianship lasts until they are terminated. So it could be for a few months or it could last until the child reaches the age of 18. How to terminate a guardianship. The biological parent has the right to request termination of the guardianship at any time. The parent must file the petition to terminate the guardianship and serve the grandparent. The grandparent has 10 days to file an objection to the termination if there is one. If no objection is filed, the guardianship will end. If an objection is filed, a court date will be set for the judge to hear why the guardianship should not be terminated. The third party or grandparent carries the burden to prove that it is not in the best interest of the child to have the guardianship end. The parent is presumed fit and capable of caring for their child or children. A grandparent can also choose to terminate the guardianship at any time. Grandparent power of attorney. An even easier and faster way to get legal authority to act on behalf of a grandchild is the grandparent power of attorney. The purpose of this power of attorney is to give the grandparent the powers to care for the minor child, including the power to enroll the child in school and extracurricular activities, have access to school records and disclose the contents to others, arrange for and consent to medical treatment, dental treatment, and mental health treatment if necessary. It also gives them access to records related to the treatment of the child and disclose the contents of those records to others. It helps to provide for the child's food, lodging, recreation, and travel, and have any additional powers as specified by the parent. Only one parent is needed to grant this power of attorney authority. Child support for grandparents. Grandparents can apply for child support for no charge with the local Department of Child Support Services. The mother and the father of the child will be responsible for child support payments as both are considered the non-custodial parent. Redirection services are provided when there is an existing court order for child support, so that support payments can be redirected to the custodial parent to the relative caring for the child. It has now come to the time where I take your questions. So go ahead and type them now if you have not already done so. And I will wait just a little while to get some questions. If you are on Instagram and you have questions, you might want to hop over to our Facebook and type in your questions if you have any. It does not have to be related to the grandparent topic that was today. Our telephone number is 678-973-2803, or you can reach us at atlantacustodylawyers.com. All right, I have a question. It says, do you think it is a good decision to let a third party have custody at any time? I think that for some people, they need help from time to time, and they may need a third party to keep their children. I personally do not like for third parties to be granted temporary guardianships or custody, because we have seen cases where when you're ready to have your child back, you're ready to have your child returned to you, it either does not go smoothly, or it's a long, drawn-out process and ends up costing you thousands of dollars in legal fees. I've also seen cases where the children were not returned to their biological parents and were kept with the third party. If the father's name is not on the birth certificate, does his parents have any right to the child? Great question. So the short answer would be no. So if his name is not on the birth certificate and he has not legitimated that child through the courts, then his parents do not have any rights to the child, because he has no rights to the child. So any rights of the father would trickle down to the grandparents. If dad had legitimated the children, or the children were born in wedlock, then his parents would be recognized as the legal grandparent. What if the parents are not consistent with the visitation schedule for the grandparents? Can I stop them from coming to see the kids? I'm not sure I understand that question, but if you're asking if the father or the mother does not exercise their parenting time, are you asking if the grandparents can exercise in lieu of the parent, or I need clarity on that question. Question from Zoe. How hard is it for a grandparent to get custody after a third party custody happened and the father isn't fit? He has no drugs and waiting trial for drug charges. Are you saying that the child right now is in the care of a third party and the grandparent wants to get custody? And is it the father's parents or the mother's parents? How long, once a party has been served in a set aside, does it take to get a hearing? I'm assuming you're asking about a motion to set aside something, and the hearing, it depends on the judge's calendar. So if the motion to set aside was filed and the other party was served, whoever filed the petition can start to ask the court for a hearing date. Okay, so Zoe said he has no job and he's awaiting trial for drug charges, and it's the mother's parents. So it's going to depend. Again, it goes back to the prongs that I mentioned before. There has to be clear and convincing evidence that it's best for the child to be in the care of the grandparent over a parent or another third party. And it has to be in the child's best interest and promote the child's best health and welfare to be placed in the custody of a grandparent. Do I believe that a grandparent would have a better standing to get custody of their grandchild versus a third party that's not related by blood? Yes, I do. But that has a lot of intricate details and a lot of things that have to be answered before I could give a definitive answer. Can grandparents deny parent visitation if the grandparent has custody? It depends on the custody order that the grandparent has. So usually if a grandparent is granted custody of a child, sometimes there is an order for that parent to have a visitation schedule with that child. If there is a visitation schedule that is court ordered, then no, the grandparent cannot deny visitation to that parent. However, if there's no court order granting the parent any visitation time, then yes, the grandparent can deny visitation to that parent. Another question from our inbox. Do you get visitation in a guardianship order? So for the temporary guardianship where it's consented to, sometimes in the order, you type up basically what you're consenting to as far as the temporary guardianship. And if that provision is put in the temporary guardianship order, then yes, you can get visitation within that guardianship. All right, again, our contact information is 678-973-2803, or you can go to our web address at farrellfirm.com or atlantacustodylawyers.com. I'm going to wait a few more minutes to see if we have any more questions, and if not, I will be signing off. When the third party had court with the father, he got custody with a list of to-dos. One was a job and pass a drug test. Does this mean he won't get the child until he completes the list? Sounds like that was a case report or a case plan that was given to that third party. And usually if you do not complete the case plan, you do not get custody of the child. However, the child sounds like it's already with the third party, so I'm not sure. I'm not sure as what the case plan was for that third party, but I would assume that the grandparent could interject and seek custody of that child. The question is, if the grandparent is raising the child, but the parents aren't necessarily declared unfit, can the grandparent adopt the child since they are taking care of them anyways? What legal rights do they have as the primary caregiver? So it is unlikely that a grandparent can adopt the grandchild unless both parents are considered or have terminated their parental rights, or the courts have terminated their parental rights for whatever reason. So that's the only way that the grandparent will be able to adopt the children that they're taking care of. In the meantime, they can ask for the temporary guardianship, which again requires the consent of both parents, or they can get the grandparent power of attorney. All right, guys and girls, thank you for tuning in today. Oh, I got one question that popped in. Let's see. Does having a formal case make me have supervised visits if I petition to legitimize and visitation for my son, or would it be unsupervised? If the question is supervised visitation the norm? No, it is not. So there has to be something egregious that has happened, something that's been done that can be proven, where you would be required to have supervised visitation. I'm not understanding what the question was. So if you petition to legitimate a child and requested for legitimation and visitation, supervised visit is not the first option that the courts think of when they think about someone legitimating their child and requesting for parenting time. All right. I'm going to be signing off. Again, our contact information is 678-973-2803, or you can reach us at atlantacustodylawyers.com. Hope you guys have a great Friday, and we'll see you soon.